Amidst global challenges and change. Amidst escalating global challenges such as ongoing conflicts, rising tariffs, expansive international sanction regimes, arbitration faces unprecedented complexities in 2025. Trade disruptions, geopolitical tensions, notably in regions like the Middle East, involving sanctioned entities in Russia, have intensified disputes across construction, energy, transport, and mining sectors. These factors complicate enforcement, jurisdiction, and dispute resolution processes, demanding greater agility and innovative approaches in arbitration to navigate an increasingly volatile and uncertain international business environment. And who better to discuss this than a distinguished panel before you? That we have the chair, Mr. Justice S. Ravindra Bhat, former judge of the Supreme Court of India, a former judge of the Delhi High Court, and former Chief Justice of the Rajasthan High Court. He has served on the bench of the Supreme Court from 2019 to 2023 and authored 142 judgments on diverse areas of law. He was instrumental in the founding of the Delhi International Arbitration Center in 2009, later chairing it for 3 years, and contributed to the 2017 arbitration law reforms that led to the amendments in the Arbitration Conciliation Act of 2019. Justice Bhat is a distinguished arbitrator appointed in high-profile domestic and international commercial disputes under ICC, SIAC, DIAC, and the Indian Council for International Arbitration, and serves as a distinguished professor in leading law schools in India. He is also a member of the Distinguished Arbitration Chambers. Mr. James Castello is an accomplished independent arbitrator with over 37 years of experience, specializing in resolving complex disputes across energy, infrastructure, and investor-state proceedings. He previously was a partner at King & Spalding in Paris. He is widely recognized for his deep expertise, having contributed significantly to the drafting of key arbitration rules and serving in senior roles within leading arbitral institutions such as the LCIA. Then we have Ms. Swee, who is a senior counsel and a partner at the WongPartnership in Singapore, leading the firm's international arbitration practice with a focus on high-value complex disputes across sectors such as energy, commodities, and infrastructure. She is recognized globally for her expertise in arbitration and asset recovery. She has also represented investors and states in significant cases involving expropriation of mining assets and denial of justice related to the South African development community. Then we have Mr. Kevin Nash, who is the Director General of the London Court of International Arbitration, LCIA, serving as the Chief Executive Officer responsible for the day-to-day management and global representation of the institution. Before joining the LCIA, he served 13 years as Registrar of the Singapore International Arbitration Center, where he played a pivotal role in administering thousands of international arbitrations and drafting key SIAC rule additions. Recognized as a global leader in arbitration, Kevin is admired for his deep expertise, practical approach, and active participation in shaping international arbitration standards. Lastly, we have Mr. Manish Aggarwal, who is a partner at Three Crowns in London, specializing in investment treaty arbitration and commercial arbitration across diverse sectors, including energy, infrastructure, telecommunication, and broadcast. Notably, he played a key role in representing ConocoPhillips in the landmark ICSID arbitration against Venezuela, securing a historic $8 billion award for expropriation of hydrocarbon assets. Manish is also a respected arbitrator and legal educator, actively contributing to leading arbitration institutions and training programs globally. I now hand over to the chair, Justice Bhat, to lead the discussion. Thank you.
Would you like me to do it here? I'm there.
However you prefer, but if that's better.
Good afternoon, all of you. It's, I think, not such a great time. Just we have had lunch, and many of you might be fighting mid-afternoon torpor. But then I hope that this session will jolt you awake, and the endeavor of this panel is to do that. It's a very star-studded panel with very experienced arbitrators, reputed names in the entire spectrum of arbitration disputes, investment disputes, and regulation of arbitral institutions. So I'm very glad to be here, and I'm particularly glad to be back in the center, which I see some of the original founders. I see Mr. Ganguly there. So it's always nostalgia which brings me back here, and I never refuse any invite. The topic is, as usual, one of the most challenging, I would say, arbitration amidst global challenges and change. At the core of it, arbitration is a means where we all strive to achieve what are our ideals in whenever we are confronted with litigation. Arbitration is a means for access to justice and accountability, as well as the existential challenges we face today due to climate change, technology, and a host of other factors. If we start enlisting them, I think the list will not end. So this panel is going to explore some of the a few of these topics, which are the ancestral working group reforms, including the proposal for a multilateral investment court and exit reforms. Then we go on to the next subtopic would be regulatory unpredictability and climate change and its impact on investment treaties. Then we also speak on recommendations for a resilient arbitration system. And the last topic would be the first one which our anchor spoke about, the disruptions which the current global economy is facing as a consequence of conflict and sanction and various other, factors. And the latest to be added in that are the tariffs and the likely economic fallout. So I will not speak further, but straight away invite James to make his views known on the ancestral working group reforms. James is also a member of the ancestral working group.
Well, thank you very much, Justice Bhat, for organizing our panel here, and thank you to the organizers for inviting me, and also to the extremely generous introduction. I think only my mother would say that she recognized me from that overly generous introduction. So my task this morning is or this afternoon, is to say something to describe a bit of what is going on in Working Group 3 in UNCITRAL, where for the last 8 years we've been engaged in a large project of investment arbitration reform. And so I'm going to approach this topic from the vantage point of our panel topic, which is global challenges and change. And before I launch into that, I'm going to say at the outset, I'm going to have to be very quick because it's a lot to cover in only 7 or 8 minutes. And I want to say that even though, as Justice Bhat said, I've been had the privilege of being a member of the U.S. delegation to UNCITRAL for the last many, many years, I am just speaking in my personal capacity. I'm not trying to represent the views of the U.S. government. So the moving force behind this project was the EU, and it was, well, it came about, I would say, by a change in circumstance that was gradual, but eventually reached a critical point, and I would say maybe a dozen years ago. The fact is that European countries are among the biggest users, the biggest adopters of bilateral investment treaties that contain investment arbitration provisions. And of course, as largely capital exporting countries, I think most of those countries, like the US under NAFTA, expected that it would use the investment arbitration feature mainly for its own nationals bringing claims against foreign host countries. But that, of course, is a scenario that changed, and probably the poster child for the change where European countries began to be the targets of investment claims would be the Vattenfall case, which was a case brought by a Swedish contractor for injury to its investment in building nuclear power plants in Germany after Germany decided to ban nuclear power. And you soon heard complaints from Germany that this was an issue that was not appropriate for private corporate lawyers to be deciding in an arbitral tribunal behind closed doors, and this system needed to change. Of course, the irony here is that Germany has more BITs than any other country, I think, in the world. But in any event, those claims, those objections were soon echoed by the European Union, and we had, for example, the President-elect of the Commission, Jean-Claude Juncker, said in 2014 that when he was negotiating a new trade treaty with the United States, he said that it will not allow secret courts, so he was referring to arbitral tribunals, to have the final say in disputes between investors and states. And similarly, the trade minister made similar comments about how the determination to have instead an investment court where the states would appoint all the arbitrators, or in fact judges, would, quote, rebalance the rights of the state and the investor in favor of the state and its right to regulate in the public interest, and that having this court would ensure, quote, that a state can never be forced to change its legislation. So, since then, there's been a further development, I think, which has affected other countries and also has been complained about by civil society groups, and that is that the number of investment claims filed over the years has increased. The amount of the awards has often increased, especially as those involve extracted resources such as hydrocarbons, whose pricing tends to be very volatile and often quite high. And so you got increasing complaints that, you know, these awards were sometimes unfair against governments whose budgets were not that large, and again, complaints about the process of having corporate lawyers behind the scenes. And so this eventually, I think, tilted the view in the mainstream press. Here's a quote from The Economist, the London Economist in 2014. If you wanted to convince the public that international trade agreements are a way to let multinational companies get rich at the expense of ordinary people, this is what you would do. You would give foreign firms a special right to apply to a secretive court of highly paid corporate lawyers for compensation whenever a government passes a law to discourage smoking, protect environment, or prevent a nuclear catastrophe. So what happened was that these types of statements led to the proposal of this court, and the EU persuaded UNCITRAL to take up the task of elaborating such a statutory or treaty scheme and for drafting it. But of course, once UNCITRAL announced this project of general investment arbitration reform, then lots of other countries came forward with other proposals. And so at one point, we had a chart at the UNCITRAL Working Group 3 with about 17 different provisions for reform, and we had a calendar for how we would cycle through the consideration of each of those over a period of 2-3 weeks of working sessions each year. So where do we stand now? We have adopted some provisions. We have adopted a code of conduct, as many of you know, for arbitrators, which deals, for example, with the issue of double hatting, arbitrators who also serve simultaneously as counsel in investor-state arbitration. We've also adopted in principle an idea for a multilateral advisory center, which would help those states who are not familiar with defending ISDS claims. We've also adopted a toolkit of recommendations to countries about what steps they can take to either prevent or diffuse disputes with foreign investors before they become claims. But we have a lot that's left to do. We have, and let me just outline the categories. We have a number of provisions which echo the reforms that were recently adopted in 2022 in the ICSID rules. And I think there's a determination to try to insert comparable reforms in the UNCITRAL rules, and those range across a great number of issues, but they're everything from having an option to have an early determination on what are alleged to be manifestly unmeritorious claims to new guidance on how to allocate costs and new time limits for rendering award. Then we have some other amendments which are, I think, going to have to be in a treaty. So the end result, I think, will be we'll have a multilateral treaty that will have many reform options, and each country that signs that treaty can decide which of the reform options it wants to adopt and thereby amend its prior international investment treaties on the same subject matter. So they might adopt the court, but they might also adopt just some reforms like allowing countries who are treaty parties to adopt joint interpretation of those treaties that would be binding on arbitral tribunals, allowing non-disputing state treaty parties to intervene in arbitration proceedings, and that kind of thing. Now, last but least, what is the future of the court? There are a lot of issues that are still left open on the court, and I think it's not clear where that is headed. Let me just identify two problems, I think, that confront those who support the court, and it's clear that a number of countries outside the EU do support it. The first is that I think the EU has had a hard time identifying a model we can all look to for how you would put together a court from a political process where only states nominate and appoint the judges that will be impartial. And they first started their model, their preferred model was the appellate body of the WTO. Then the appellate body fell apart, so that was not a good model. Then they turned to the ECJ, but there are a number of scholars, including Philippe Sands, who did a study on this, who show that the vast majority of judges appointed to the ICJ tend to be part of a political process. They're a friend of the trade minister or something like that. And then they've now turned to the ECJ, and for those people who are not fans of and view the Achmea jurisprudence as rather politicized, that's not terribly reassuring either. So we have a lot of questions about how you appoint members of the court, and if you look at the current statute, you'll see it has many tiers in it. It takes quite a while to get through it. I think the other big problem with the court, that the court adherents face, yeah, this is my last point, is that to go back to the quotes I had earlier from the EU officials and from The Economist, these are rather misleading portrayals of arbitration as it is today. So you don't have to invest in MIC, you don't have to adopt a multilateral investment court to get rid of secrecy. There is a Mauritius Convention. Countries could sign the Mauritius Convention. It's been open for signature for 10 years, and there are very, very few countries who've ratified it. But that is a solution to adopt the UNCITRAL transparency rules in arbitration. You also don't have the risk, really, of regulations being overruled by arbitration tribunals. There are very few cases in which a party has ever sought to overturn a public health or safety regulation. Even Vattenfall didn't challenge Germany's decision to ban nuclear power. They simply said they wanted compensation from the decision. So I think these are the kinds of issues that are faced, and I don't really know what the outcome will be on a court. Thank you.
Thank you very much, James. Before we proceed to explore the topic further, depending on the time constraint, I'd request Kevin to share his views.
Thank you. Good afternoon, everyone. Maybe I will set the context for me and UNCITRAL. So I had the privilege and the pleasure of sitting for Singapore, and I found that there was this delegate from the United States that I kept agreeing with, so that we would second the intervention of the distinguished delegate from the United States. We would second the intervention from the United States, and that distinguished delegate in the delegation, of course, was James, who is now the deputy chairman of LCIA. And I can also recall talking to Swee before my first UNCITRAL, I think 8 years ago, and she said, if you make one sharp intervention during the week, you can consider the week a success. So I took it from that to finding myself making 40 or 50 interventions during the course of the week. I wanted to start with the importance of what has happened in Working Group 2 and why this matters for an institution. So one thing that we worked on in Working Group 2, which I think has been critically important, is getting the expedited arbitration rules. And this is important for SMEs in India. It's important for Indian parties. And what this really did was allow to have expedited arbitration, similar to what we see in Indian ad hoc arbitration under the new legislation in domestic cases, to have time-bound arbitration. So this was quite important. And for an institution, we are really looking at the discussions in UNCITRAL to try to get the lay of the land and to try to understand what is really important to states, what is important to representatives of corporate groups. So when we look at the provisions in the expedited arbitration rules. Again, because it's ad hoc, we had to do it a bit different because you don't have an institution that is able to grant the extension. And I think that all of us would know that thorny issue of the time limit for an award to be rendered under the expedited procedure. So whether it's 6 months, 9 months, a super expedited procedure at some institutions, how do you extend that time? Because if the time is not extended, now the arbitral procedure is no longer in accordance with the agreement of the parties, and that award will ultimately be a nullity. So we came up with a mechanism whereby the tribunal could extend and then provide a final extension. And I think that was a result that worked for all of the delegations, and I think it is a relatively slick way of doing things. When we look at Working Group 3, I think ultimately the question, and again very relevant for India having backed away from traditional ISDS, the question is whether we want incremental change or systemic change. And so I come from a camp, speaking for myself and not an institution or any larger body of arbitration stakeholders, where I actually think that ISDS is working quite well. And if you look at the LCIA caseload, LCIA's caseload involves around 14% of parties are state parties. So you can have parties that may, or states that are looking for bigger change, but you can also have or arbitrations where they're going to choose a primarily commercial institution, or you can have investment contracts. So I think the system is working well, offering choice, but for institutions, the most important thing that we get out of UNCITRAL is really being able to take the temperature of what users, states, organizations really want.
I'd like to pose a question to James. You see, the Working Group 3 had discussed a draft statute establishing a standing mechanism to resolve investment disputes. In particular, the statute contains provisions on the selection and appointment of members of dispute tribunals aimed at enhancing diversity. Any thoughts about these? Because there have been a number of studies on diversity issues, both in terms of gender as well as in terms of diversity of nationalities. So what is the learning that one gets from this?
It's a good point. So what you're referring to is the current draft of the statute that would establish a multilateral investment court, the EU's proposal, and there's a multi-tiered process for selecting the judges, first who will serve on the court overall and then who will serve in an existing case. And the statute as currently drafted requires that the selection of those judges take into account diversity both as to gender and as to geographical and ethnic background. I think the challenge that is faced is how do you guarantee that? For example, you can assume that the court will initially have 27 European members, and then gradually perhaps other countries in, say, Latin America or Africa or other jurisdictions might join. And the question is, how do you guarantee diversity if you have an unbalanced membership? And we're grappling with that, but that is an issue that delegates realize is a live issue and an important one, because everyone concedes that the current pool of investment arbitrators is not terribly diverse.
Now we move on to the next topic, which is, Kevin, on to you, recommendations for a resilient arbitration system. And I would request you also to address the issue of data protection and how institutions go about this, because I think this is an important area, at least in this country. We have to get sensitized to that, because institutions, at least in Europe, are mandated to follow the GDPS. And so I'd like
Sure.
to hear.
And maybe I could even highlight that off the top. Institutions are data controllers. You're looking at a patchwork of data protection laws around the world. So when you have a global institution like LCIA, this is something that is critically important. Our institution's going to be baking that into the rules. can this be dealt with by way of soft law? Surely the tribunal should be discussing it in Procedural Order 1, so this is something that's important. When I was trying to craft what I was going to say in terms of how do you make arbitration resilient and how do you make a resilient arbitration system, I always go back to any analysis and I start with the advantages of arbitration and why we choose arbitration to begin with when arbitration is operating perfectly. So arbitration operating at its highest is going to be fast, cost-effective, efficient, choose your own decider, limited avenues of appeal, confidential, maybe, and then enforceability under the New York Convention. So that's why arbitration is the preferred mechanism for resolving cross-border disputes. But we're also living in very complicated times for dispute resolution. It is ultimately an age of inflection where we're looking at trade wars, tariffs, sanctions, armed conflicts, being able to leverage and harness technology. And I was recalling that there was principles that were set up in London, the London principles, the centenary principles for defining a safe seat of arbitration. And I was wondering maybe in conjunction with the DIAC and at the Delhi Arbitration Weekend, whether we could come up with institutional principles, or I could at least endeavor or aspire to come up with these principles of what institutions can do to ensure and really be the guardians of the arbitration system. And when I talk about being a guardian of the system, I always think back to the Chief Justice of Singapore, Sundaresh Menon, who talks about how institutions move from mere stewards to the true thought leaders in arbitration. And if you look at that and if you think about it, and if you look at some of the complexity of the institutional provisions and the kind of decision-making is required, I think that this is increasingly true. If you also look at some of the most important innovations in arbitration, these tend to come from the institutions. I always thought that it was a beautiful case of timing to look at the KCAB when they had come out with their virtual or remote hearing protocol right before COVID, that then all institutions were able to adopt. So some of the most important innovations are coming from institutions. So what are those qualities that institutions have to marshal, shepherd, and protect, and what should institutions be in order to make sure that arbitration stays as this most preferred mechanism for resolving cross-border disputes? And I will look at this to a certain degree through the lens of LCIA. I think that the first critical component is independence and integrity. And when you're looking at an institution, I think one of the ways that you can judge the success of an institution is if you had parties that had chosen LCIA arbitration with a London seat, and it was a party from a faraway jurisdiction. If that party was confident that they could come to London and come to LCIA and still get justice, even against a very influential UK entity, then you have achieved that independence. And that is one of LCIA's real calling cards. I think unlike many other institutions, LCIA is beholden to no one. So we're not under the auspices of any chamber. We are a purely independent institution, and I think that is why parties from all around the world are choosing LCIA. And when I say all around the world, I really mean all around the world. In 2024, there were parties from 101 jurisdictions. We looked at LCIA arbitrations over the past 6 years, 161 jurisdictions, 70 different seats of arbitration, 99 different governing laws. And I think many of these parties are choosing LCIA because of this independence. So that's what I would look at as a first principle, the independence and integrity of an institution. Now, I will caution that I have 8 of these principles, so you can stop me along the way, but I will try to accelerate them when we talk about the innovations of expedited procedure, and we'll move these along a bit quicker. I think the next principle is really having arbitration be commercial and predictable, and it almost asks and augurs to the question of whose arbitration is it. There is an interesting tripartite relationship in arbitration. You have the relationship between the parties in the tribunal, the parties in the institution, the tribunal, and the institution. So is it the parties that are governing the arbitration? I think ultimately we lean in favor of that. And when I talk about being commercial and predictable, often when we're appointing arbitrators, and I was an appointing authority for a long time, what parties would always tell me is that they want arbitrators that are commercial, commercial. We want arbitrators that understand the business, commercial. And this has really informed how we're appointing arbitrators at LCIA. And that predictability. We're often talking about how fast arbitration needs to be, so there's 6 months, 3 months, turbocharged arbitration. I think that arbitration needs to be exactly as fast as the parties want it to be. And I think where arbitration starts to fail is when there is delay, unbargained for delay that has been occasioned by the tribunal or has been occasioned by the institution. So having that predictability so parties have a sense of how long is this arbitration going to take. The counsel can advise their clients that this is how much we think it's going to cost and this is how long the arbitration is going to take. And that third, which I can deal with quickly, is the cost effectiveness of arbitration. So going along with being commercial and predictable, and this is particularly important in India, and I have been coming to India for more than a decade, and every time I come to India, I represent myself more as someone that is promoting institutional arbitration rather than a specific institution. And I will say the same thing every time, and I think the percentages are improving. All else equal, institutional arbitration is more cost effective than ad hoc arbitration. And the reason for that is because there is a direct relationship between the overall duration of an arbitration and the costs, and we will always have the benefit of the ICC study, cost and duration study, where we see that those institutional fees only make up 3 or 4%. And I will leave it there for a second. We're at 3 out of 8.
You cannot finish your 10 principles.
8 principles, but maybe we'll cut it down to 4.
Thank you very much, Kevin. That's a lot of thoughts packed into those 8 minutes. Recently, there's been this Queen Mary Whiten case survey on arbitration and arbitration institutions. Yes, you're right when it comes to the parties' choice. LCIA scores very high. But if I'm not wrong, my recollection is that some of the Asian arbitration centers are also not far behind. They're all catching up. So what are your thoughts, Ko, on this topic? And
I think Kevin, having been in and worked in an institution, really shares a really good perspective of the important role that an arbitral institution plays in building a resilient arbitration system. And the principles which he touched on right at the start, that of independence and impartiality, it being commercial and predictable, cost effectiveness, and I can't wait to hear more about the other principles, because I think arbitral institutions, like what Kevin says, I echo what he says, they play an important role. But what I think is even more, and maybe equally, or what also needs, because you need both hands to clap and you need all part of the system to work together, like you talk about a tripartite system. You talk about a relationship between the parties and the arbitrators, the parties and the institution. And I think in this relationship, the parties are important, the counsel are important, but the key decision maker, the tribunal members, is what I feel is the key to making a resilient arbitration system. Arbitration came about, and we go back to its very beginning, about the idea that it's here to resolve commercial disputes. It's efficient, it's cost-effective, and the tribunal members are commercial-minded, they are savvy, and they would have this dealt with in a confidential manner. The award will be final, there will be no appeal. The difficulty of how the system and the complexity of disputes have added to this, and also the heavy caseload of arbitrators who continue to take on many appointments despite the fact that perhaps there are time challenges to it, I think causes a huge shake to the entire system. And why do I say that? Because while the institutions may have great rules that sets expedited timelines, the institution may penalize an arbitrator if an arbitrator does not issue his or her award within a particular period of time. But ultimately, other than all these various rules, penalties that can be imposed, it is still down to the tribunal member. Because the tribunal member can simply ignore the penalties, can ignore the emails from the institution chasing them, and the tribunals can, not. Even when it comes to scrutiny of awards and the institutions may give certain suggestions, the tribunal members may very well ignore that. And that's why I feel that at the end of the day, if you talk about a resilient arbitration system, and if we have to choose one, while I accept that everyone is important in this equation, the most important to me is the tribunal members. They need to be proactive, they need to manage the case well, they need to know the rules well, they need to comply with the rules, they need to move the case along, they need to understand that it's commercial, and they need to be transparent and accountable. My clients go to arbitration, it is true, because they want the confidentiality. But the fact that they want the confidentiality means the confidentiality of the documents, the arguments, what they are putting inside the case, but they do not want confidentiality vis-a-vis the tribunal members. What do I mean by this? They want tribunal members to be held accountable. And the very fact that awards are confidential, the very fact that in quite a lot of situations where the awards are the subject of challenge, that arbitrators may not be named in these judgments, that it leads to this question of, well, it is something that takes place in secret, like something that James mentioned in his opening. And I was just thinking, one of the approaches that the Singapore courts have taken, which I have to say there are proponents and oppositions to the approach of the Singapore courts, is that when it comes to challenges and setting aside, they have started to name arbitrators. They have started to name arbitrators in their judgments. And it isn't the idea of, it's not about shaming, because at the same time, when they do not set aside an award, they likewise name the arbitrators. But the whole idea of naming arbitrators in judgments is to enhance the accountability and transparency. And that, I think, to me, that resilient arbitration system can only be resilient if you have tribunal members who truly believe in the system and want the system to work well, and coupled with that, the courts who continue to uphold the system.
Thank you. Now we move on to regulatory unpredictability and the impact of climate change. So, Manish, I would invite you to speak on this.
Thank you, Justice Bhat, and good afternoon, everyone. I wanted to take the next few minutes just to share a few thoughts on how climate change related considerations are reshaping the system of investment treaty arbitration. Now, I have been warned that there is actually a separate panel dedicated to that topic, so I don't intend to steal their thunder. But what I intend to do is to just briefly touch upon three different themes. First, just to give you all a flavor of how environmental and climate change considerations have manifested themselves in investment treaty cases to date, and I've been involved in quite a few of those as counsel. Second, I wanted to briefly talk about the recent advisory opinions of the International Court of Justice and Inter-American Court of Human Rights. And finally, I'll just share a few thoughts on what these developments mean in practice, both for states and investors. And just kind of moving on to the first part, we have seen two broad categories of cases in which environmental issues have played out. First are cases involving state measures that have affected more conventional forms of energy. So think about revocation of permits for hydrocarbon exploration, phasing out of coal. The second category of cases involve claims by investors in newer energies, which have found themselves faced with state revocation of subsidies or incentives that were offered to attract those investments in the host state. So again, I think the best example of that are several cases against Spain under the Energy Charter Treaty in relation to adverse measures that affected renewables investors. And I was involved as counsel in several of those. I think the key point to note is that most of these cases have arisen under older generation treaties. Most of these were entered into in 1980s and 1990s, and they contain very broad protections. And unlike the newer generation treaties, they do not provide for express carve-outs for a host state's right to regulate. And in each of my cases, these questions have become very, very complex. And you often look at an investment treaty case and you break it down in terms of jurisdiction, liability, and quantum. And the considerations that we will be discussing have manifested themselves at each of those stages in different ways. And I think these questions are becoming more complex, particularly if one looks then at how the climate change obligations, the general law, interact with the investment treaty obligations. And I think that brings me to the recent advisory opinions. In July, as many of you will have seen, the International Court of Justice provided an advisory opinion confirming that all states have binding obligations under both international climate change treaties as well as under customary international law. And those obligations include preventing significant harm to the environment through due diligence, using all available means at the state's disposal to avoid harm to the climate system, and to cooperate in good faith with other states. And the court went on to say that if a state breaches these obligations, then that does constitute an internationally wrongful act, which then entails consequences for the state in terms of satisfaction, reparation as well, and that includes an obligation to pay compensation to the injured party. And a few months earlier, the Inter-American Court of Human Rights took a similar approach. Now, of course, these advisory opinions do not bind the states, but they are interpretations of international law by the highest forms of the judiciary. And the way some of the separate opinions of the ICJ opinion articulated that tension between environmental obligations and the investment treaty obligations is quite notable as well. And I'll just give you one example. Judge Sarah Cleveland, in her separate opinion, drew attention to the chilling effect of investment arbitration on climate regulation. And she stressed that when it comes to interpreting and applying investment treaties, they must be undertaken in light of the obligations that states have in terms of the climate change treaties and the customary international law. Now, one can have a debate as to whether investment arbitration does cause that regulatory chill, and I think it's something we'll likely pick up in debate. But I'll conclude just by making a few observations about what this may mean in practice for both investors and states. If you look at most of the cases about regulatory changes, so leaving aside executive measures, but just focusing on regulatory and legislative changes by states, what lies at the heart of these disputes is this question: where do you draw the line between legitimate, non-compensable regulation and between a compensable breach of investment treaties? So put another way, how far can a state go with its regulatory change before it tips into the territory of having breached its investment treaty obligations? And often, it may be kind of a narrow way of looking at it, these questions are really about allocating the economic burden of the change. Who should bear that economic burden when the state has to implement that change? Should it be the state or should it be the investor? And that debate often manifests itself when the tribunals are interpreting and applying the fair and equitable treatment standard, the protection against unlawful expropriation. And the reality is that the jurisprudence that we have so far is highly fragmented, and that leaves both investors and states with a lot of uncertainty. For example, in a lot of my cases, the tribunals have sought to strike that balancing act, right? So what the tribunals are saying is, just because a state has entered into investment treaties doesn't mean that it is prevented from changing its laws and regulations. You can't expect the regimes to remain petrified. That being said, there are limits to a host state's right to regulate. And in particular, where a state has made express stability promises whether in a contract or in a law, then that is where if a state does implement a change contrary to that stability promise, that it may fall foul of its treaty protections. But I think the more difficult question you have is where you don't have those express stability promises, you don't have a contract with the state, you don't have anything embodied in the law, and the state does go ahead and change the law, does that then constitute a breach of the state's treaty obligations? And that's a very complex issue, and I anticipate that the recent ICJ advisory opinions would likely make that debate even more complex, because you can now see the states arguing that the investors, particularly in sectors that are affected by climate change and environmental regulations, and that pretty much covers most of the industry sectors, could not have had a legitimate expectation that the states wouldn't implement a change. Now, if you're acting for the investor, what you're going to say is, well, a subsequent ICJ opinion cannot retroactively alter the rights that I have as an investor under investment treaties. And again, I anticipate that debate is going to continue. I'll just conclude by noting two trends, and I'll then hand over to the others. First, I think I do expect in terms of future trends that domestic climate regulation will tighten across the globe. So think about stricter emission standards, more ambitious phase-outs, and greater scrutiny of any kind of fossil fuel production. And the second, I think, I do expect that the treaty drafting will evolve even further. And we've seen over the last decade or two, states focusing quite heavily on the drafting of treaties, and particularly in terms of creating carve-outs for their right to regulate. Now, some of the early cases that we've seen under those carve-outs don't really give you a lot of confidence as a state. Particularly, I have in mind the case of Ecuador and Colombia. And I think what we'll see in terms of treaty drafting is kind of more precision in terms of the kind of regulatory measures that are shielded from liability. So something that we'll have to grapple with in the coming years. I'll pause there.
Thank you, Manish. Just taking the idea forward, the last idea. We have the India-Brazil BIT, Article 12, then we have the Japan-Bahrain BIT, and the Oman-Hungary BIT. And also I'm told there's a Netherlands treaty, which give a special emphasis and a kind of shield to these kind of regulations. Now, our next speaker is James, and I would give you a very pointed question, but it's pertinent to your first presentation as well. And it's very relevant, and it resonates with this topic, which is treaty fragmentation, and the follow-up on this is the fragmentation of jurisprudence. You see, when we have multilateral institutions, like you mentioned the WTO chamber, of course the chamber's appeals collapsed, and it didn't really go forward. But for those 20-odd, 30-odd years, you had some kind of consistent jurisprudence which the states could expect and act upon. Whereas when we talk of investment treaty arbitrations, they're essentially getting into the sphere of public international law, and you have, that case to case, the consistency one doesn't see there. And going forward, especially in critical areas like environment and maybe even in public health, there would be huge concerns. The OECD has estimated that about $6.3 trillion of investment is expected for, compliance with environmental standards. So what's your position on this?
Well, thank you, Justice Bhat. You've just made one of the central arguments, I think, of those who support establishing a multilateral investment court, which is that I didn't get a chance to mention, but part of either the court or a separate adjunct to the court would be to have an appellate mechanism, an appellate body, so that investment arbitrations or investment decisions by the court, either one could be referred to the appellate body. And one argument for having an appellate body is that it would allow a harmonization of jurisprudence across jurisdictions and defeat the kind of fragmentation you're talking about. I wanted, in light of what Manish has said, I wanted to mention one other sort of multilateral institution which hasn't exactly collapsed, but it has, I think, experienced a severe body blow, and that's the Energy Charter Treaty, because it's very relevant, I think, to what Manish has just talked about. As many of you will know, the EU countries withdrew en masse from the Energy Charter Treaty. And those governments that gave explanations said at the time that the reason they were doing it is they didn't want the ECT to compel them to compensate investors in old hydrocarbon type of energy if they, claimed an injury from some policy. What makes that odd is that Manish did a very good job of distinguishing between those kinds of cases that involve historic forms of energy, hydrocarbons, and those that involve claims by investors in wind and solar and renewable energy. Vattenfall, for example, a nuclear power case, was brought under the ECT. So it is ironic that we would be withdrawing from the ECT at a moment when probably those kinds of energy need encouragement or protection against perceived risks. And in that context, the International Energy Administration issues every year a World Energy Outlook report. And as of a couple of years ago, they said that between now and 2030, which is now only 5 years away, we must go from a current annual new expenditure in renewable energy of $1.2 trillion a year to $4.2 trillion a year. And the report made the point that most of that money is going to have to come from private capital. Governments don't have that kind of money. And so the question is, the report concluded by saying those private investors will need to have some guarantee against risk to encourage them to do that investment. And in that context, it seems like an odd moment to withdraw the protections of the ECT.
Thanks, James. I think time is, of course, we still have some time. Now I'll turn to Ko again, and I would invite you to speak on disruptions and its impact on investment treaties and disruptions generally. And we live in an age of disruptions, and I think you have some experience in handling the disruptions caused by sanctions in the wake of the conflicts in Ukraine or the annexation of Crimea. So over to you.
Thank you very much, Justice Bhat, for that question. I think increasingly in this world where there's a lot of geopolitical tensions and where everyone is saying that uncertainty is the only constant, there are many arbitration conferences where we constantly talk about international arbitration and how international arbitration is impacted by situations of conflict and the interaction between the two. And I was very inspired yesterday when I was listening to Lucy Reed, who delivered the opening remarks at IPBA Arbitration Day. And she made a very simple point, which then got me thinking deeper about this particular question. She said that, people speak about this, but what we fail to understand is that while you have all this conflict situation, where you have situations of armed conflict, and you may have situation of act of war, international arbitration actually does not resolve the armed conflict. International arbitration is not there to resolve the conflict situation, but international arbitration is there to provide and to resolve legal rights, disputes, claims, counterclaims between commercial parties as well as between commercial parties and states. So that then got me thinking as to, when we look at the conflict situation and we look at situations of conflict, does international arbitration continue to be relevant? And that's when I say it is particularly in situations of conflict that international arbitration becomes of even greater relevance. So let's talk about Russia and Ukraine, which you mentioned. You talk about the annexation, which first, the annexation of Crimea, 2014. That was some 11 years ago. And what has happened and what has resulted from that annexation? International arbitration has given remedies to Ukraine investors who have brought investor treaty claims under the Russian-Ukraine bid, relying on the fact that the Russia's action, insofar as it affected Ukraine investors who were in Crimea, then now had a recourse. So there have been, since 2014, these various investor state claims that have been brought and has resulted in awards that were in favor of the investors as a result of the fact that they have stated that Russia has taken various steps of expropriation, breach of fair and equitable treatment. And that is interesting because it shows that even in a situation where we are not talking about do we accept that the annexation is legal or illegal, the tribunals have come forward to interpret the bilateral investment treaty, interpret the moving treaty frontiers rule, look at the bilateral investment treaty, analyze it with legal principles, public international law principles to ascertain, is there still a foreign investor? Yes. Ukraine, Crimea. Is it now an act of Russia? Is it an investment within Russian territory? Yes. Russia will not deny that Crimea is part of Russia. So then they then go on to analyze to say, fair and equitable treatment, has that been breached? Is there expropriation? And at the same time, us as counsel, and when there's situation of conflict, that's when the queries come constantly to counsel as to what do we then do? What recourse do we have as commercial parties? Do we have investor treaty recourse? And do we have contractual recourse? And I think that brings me to the next topic, which I think is extremely important in where we are today when we talk about sanctions and how they affect this broader principle. And I'm not even talking about just purely international arbitration. But I think when we look at sanctions, we must look at sanctions from the perspective of how it impacts the access to justice. And when I talk about access to justice and the impact of sanctions, I'm talking about looking at it from the perspective both of a non-sanctioned entity who is suing a sanctioned entity and from a sanctioned entity who is suing a non-sanctioned entity. So we must always consider it not just from the perspective of someone who is not subject to a sanction, but also a party who is subject to sanctions. When the war first started, and the rules across the institutions and the legislation were not clear, there were many legitimate Russian entities and individuals who could not get any access to counsel. And that's because a lot of the counsel were prohibited, whether is it within their law firm, whether prohibited as a result of certain uncertainty relating to whether that formed an exception, and the Russian entities did not have access to counsel. Obviously, that has changed, that has evolved. With time, institutions have made it clear that they will accept payment even if there's an issue and it deals with a Russian entity. Counsel have also obtained exceptions from their respective, whether is it from the Office of Foreign Control, depending on each jurisdiction. They have given exceptions to allow Russian entities to have access to counsel. There's also another very big problem, the neutrality of the seat and the neutrality of arbitrators. It has posed a very, very big problems to sanctioned entities because when they enter into the various contracts and they chose a seat which they have perceived is a neutral seat, as a result of certain laws that may bind the seat, for instance, and I think this is something we are all very familiar with, EU Regulations 833 of 2014. Which does impose quite significant sanctions against dealings vis-a-vis Russian entities and Russian individuals. As a result of that, many of the arbitrations that were originally seated in European seats start to face challenges. And that's when the Russian parties are speaking to various other, whether is it India, whether is it Hong Kong, whether is it Singapore, to say, should I change my seat? And it is not just a matter of them changing the seat because there is, why is it that you may say, oh, why is it just so reactive? Just because, there's this EU regulation, it doesn't mean you have to change your seat. But it does, because if it's seated in a particular EU jurisdiction, they may then face issues with the setting aside of the award because a court in an EU state would be bound by EU law. That is something that always constrains the way that they look at certain of this impact. It may affect the EU seat's view of public policy because public policy obviously is something which is very unique to each of the jurisdiction in which you are in. And as a result of it being an EU state, that public policy plays an even bigger role. And that explains why, it becomes a question of, do you get access to justice if the seat continues to be in a seat, which as a result of conflict no longer is neutral? And the next really big point that I want to speak about is enforceability of awards. And this is quite interesting because we're talking about enforceability of awards inside Russia and enforceability of awards outside of Russia. And we have seen EU decisions. I think there was a recent one in Germany where a Russian party was awarded it made an advance payment for supply of equipment. And as a result of the trade embargoes, the company no longer supplied this equipment to the Russian party. The tribunal found in favor of the Russian party and said you should get back your advance payment that you had made for the supply of equipment. They tried to enforce this in a German court. And the German court said, we can't enforce this because it may potentially be in breach of the EU Regulation 833. And the reason why they say that is because they said that this supply of this particular equipment may fall within the prohibited equipment within EU Regulation 833. But if you take a step back and you consider it, well, it is asking you to make payment of what is due under an arbitral award. And how does that breach EU 833 of 2014? So that becomes a huge challenge. And then when you talk about enforcing an arbitral award against a Russian party in Russia, that also has challenges because most recently the Russian court did not enforce a SCMA award, which was seated in Singapore because of the sanctions that the MAS, Monetary Authority of Singapore, had imposed on Russia. And even though it was very restrictive, it was in a sense very limited sanctions, which only prohibits anything that goes towards the financing of the war. Singapore was in a sense listed as an unfriendly nation like many other nations. So I think all this is, to me, it does impact and call on the bigger question of access to justice, the commercial parties not having access to justice.
Thank you. Manish, your thoughts on this? As a practitioner, on the practical side of it, when it comes to remittances, banks, and how counsel or arbitrators are funded or institutions are funded, and how often do you take recourse to these exceptions going to the concerned officers, and what's the delay, the administrative part of it? What is your experience and what are your thoughts?
Thank you, Justice Bhat. And I think on how institutions are dealing with it, I might even invite Kevin for his views. But I did want to share, picking up on what Swee said, two war stories from my cases, in which we had to grapple with issues relating to sanctions. First is an investment treaty arbitration, in which we represent a state in an arbitration under a treaty that does not specify either the institutional rules or the seat of arbitration. And therefore, the tribunal that was constituted had to decide on both. Now, for the seat of arbitration, we pushed for a seat in either Geneva or Stockholm, and the claimants objected, arguing that they would face the kind of issues we and you identified, including in terms of kind of various payments that would have to be made. And after a really lengthy procedural battle, the tribunal chose Singapore. Now, Singapore, as we all know, is an excellent seat, but that was not the right seat in our case for various reasons that were specific to our case, and I won't go into those. But I think what you're finding is that effectively with investment treaties, and most of them tend to be silent on the seat unless you're choosing exit arbitration, you are effectively rolling the dice in terms of the choice of the seat in any case, and then you don't really know in any non-exit arbitration which supervisory courts you're going to get for your arbitration. And I think another manifestation of that we are seeing in our commercial cases as well, where parties have actually specified in their contracts the seat of arbitration. But even in those cases, the sanctioned parties are applying to the tribunal to move not only the venue of the hearings, but to move the juridical seat of arbitration. And that's raising a whole host of issues. And again, in my practice, I've seen tribunals being reluctant to alter the juridical seat, but that's not guaranteed, primarily because of the access to justice issues that are often being ventilated, even in commercial cases. Just another war story from one of my other London-seated LCI arbitrations, which involved a Russian party. And the concern was, again, the Aggarwal law that Swee had mentioned, which allows Russian courts to essentially block arbitrations involving sanctioned Russian parties. In our case, the opponent, a Russian party, participated in the arbitration, but against the backdrop of its various group entities frequently breaching arbitration agreements, it refused to give an undertaking that it would comply with the arbitration clause for the entire duration of the case, and that it would not invoke the jurisdiction of the Russian courts. And we used that refusal by the Russian party to give an undertaking to approach the English courts for a preemptive anti-suit injunction, asking them to restrain the counterparty from bringing proceedings. And there you had an interesting debate. Here you had a party that was participating in the arbitration, but had, through various group entities, a history of non-compliance and of invoking the Russian court's jurisdiction. But again, in those circumstances, the English court did grant an injunction, and it accepted our argument that granting the injunction would not prejudice our opponents, who could always come before the court and provide the relevant undertakings. And if it had all the intention of complying with the arbitration agreement, there was nothing stopping it from offering that undertaking. But I think that episode shows another reality of the sanctions landscape, which is, I think, the growing importance of injunction practice. I think, when we all started our careers, we were not really grappling as much, with that. But I think increasingly we are now having to navigate a very complex sanctions landscape, combined with the world of anti-suit injunctions, anti-arbitration injunctions, and anti-suit injunctions. I will just make one final point in terms of unpredictability and how these issues are going to kind of play at the enforcement stage as well. And let me say a word about India, because I think it highlights the ripple effects that Swee mentioned of sanctions, even in jurisdictions that have not themselves imposed them. And the limited time, I can't really do justice to the position in India, but I would commend to you an article written by a dear friend of mine, Raj Pachmatia of Khaitan & Co., on how the various issues involving Russian sanctions are likely to manifest themselves in the Indian context. But let me give you one example. Imagine a London-seated arbitration involving a Russia party, like the one I just mentioned earlier. The Russian court issues an anti-arbitration injunction restraining that particular arbitration. The arbitral tribunal goes ahead and issues an award, and you need to enforce that award in the Indian courts under the New York Convention. How are the Indian courts going to grapple with that? And let's say there is also, the Russian party also took the matter to Russia and obtained a conflicting judgment from the Russian courts on the merits, which is completely contradictory to the award. So the Indian courts may find themselves faced with an arbitral award rendered under such an arbitration clause that the Russian courts have held is void. They may also be faced with the enforcement of a Russian court judgment, which is completely contrary to that. And I think that I see as becoming a real battleground in India. And again, I would commend that article to you. But again, I think this is something many jurisdictions will have to navigate and are navigating. And I do see some scope for real rich debate in the Indian context as well.
Interesting, because then we are looking at two public policy issues in principle. One is the public policy which is set up against the enforcement of a decree, a court decree, as against the enforcement of an award, which has been prohibited from proceeding. Very interesting. So I think, would you like to volunteer some comments on this topic?
Sure. I think for institutions, sanctions is a part of day-to-day case administration. And London kind of is operating or offering the best of both worlds. So LCIA works under a general license from the Office of Financial Sanctions implementation, and that is typically the trick for institutions. How do you handle the movement of money? I think there's tales out there in the ether of, say, institutions with a respondent that has a counterclaim, and that counterclaim, the payment on it might stretch out a year, multiple years. And then I think institutions also have to be cognizant about the nationality and the appointment of arbitrators. I think what's been really interesting in LCIA cases is that Russian parties are often nominating UK nationals or EU nationals. And then as Manish said, I think that's a very interesting case in terms of a preemptive injunction, because I think the challenge is that the Russian party may go to the Russian arbitrage court, say they've been adversely affected by sanctions, and now you're going to have that anti-arbitration injunction, and exactly as postulated, what then happens in a different jurisdiction for enforcement. But I would say for Indian arbitrators, I think institutions have quite quickly warmed to the appointment of Indian arbitrators in cases involving Russian parties. So I think that is an interesting area, particularly for Indian arbitrators.
Yeah, I wanted to sort of draw from what Manish said about the injunction and how the increasing role, and particularly in this situation of conflict, that we really see the interplay between international arbitration and the role of the courts and the national courts in this. They spoke about the Aggarwal law, and they speak about Article 248, and that is really the whole line of Unicredit and the Gazprom decision, where in essence what had happened in that instance is that the Russian court had essentially said that the party had started because of the Article 248, the party then said that I was not able to get access to justice if I gone on to arbitration, so they then started the suit inside the Russian arbitration court. And what then happened was that the UK Supreme Court, I shouldn't say rightly so, I should keep it open, granted an anti-suit injunction against it proceeding in the Russian courts. And while that remained the case, and what ultimately happened was that the Russian courts then decided to impose extremely high penalties on the parties, on the commercial parties, which then led to a situation where the party ultimately had to withdraw its anti-suit injunction before the UK courts. And so that interplay, I think, is really something which we see all the time. So a lot of the queries that comes to me, whenever it comes and is related to sanctions, is about getting the injunction vis-a-vis looking at this sanction situation. Another point that I also wanted to make is that I think courts as well as tribunals must be much more rigorous about interpreting sanctions and deciding whether a party is truly prohibited by the sanctions from performing its obligations under the contract. I mean, having read many cases, and I'm not just talking about sanctions vis-a-vis Russian parties, but also those who are sanctioned on the OFAC list. Banks tend to take a very cautious approach. Banks have their internal lists. Banks would sanction a lot more parties than what is even on the OFAC list. And often they then do not perform their part of the bargain by saying that you're on my own internal list and I'm sorry, I'm not going to perform my part of the bargain. But our Singapore Court of Appeal has actually been very robust in saying that, well, this is not on the OFAC list, it is your own internal list. How could you then just rely on something that's purely internal to then say that you are then not going to perform your obligations? So the Kuvera decision of the Singapore Court of Appeal, I thought that was a really interesting read, because it's one of the very few cases where the adjudicative body is actually truly analyzing and deciding, do sanctions actually apply? Do sanctions actually prevent performance? Yep. That's what I wanted to add. Thank you.
Thank you. I think now we have a little time before the session closes for a few questions from the audience. Yes.
Good evening, myself Aditya. So my question concerns about investor-state arbitration. So I rightly pointed out just a Bhat that there are a lot of jurisprudence regarding the settlement of disputes. So now if you get a case like CMS versus Argentina, Morocco, Taiwan and so there is a trend of exploiting the resources of third world countries. So take off the panel over this. Because by exploiting their MFN and equity and fair treatment clauses.
What's the question?
The question is why this trend that only the third world countries, the global south, they exploited their resources by over-interpreting their MFN most favored nation clause and fair and equitable treatment clause. Whereas in the case of anti-dumping treaty by US, Canada, the favor is always in the favor of first world countries.
Can you point to any particular decision?
Yeah, I can point to Philip Morris versus State of Earthquake
Okay.
or CMS versus Argentina.
Could I think as I understand your question, is it whether the investment treaty decisions have displayed some systemic bias towards more developing countries? I don't believe so. And actually, and James mentioned that earlier. If you look at pretty much the investment treaty jurisprudence in the last kind of 10 years, actually quite a few developed states have been at the receiving end of these investment treaty claims as well as adverse awards. And when I was part of the IBS subcommittee on investment arbitration, we also undertook a study against kind of this broader backlash against investment arbitration, and that argument was often used. But the reality is that if you look at the actual decisions, this broader kind of clamor against ISDS is not really borne out by the actual decisions. You often hear this argument about investment treaty arbitration being kind of stacked against states, particularly developing states. But again, statistics will show that most cases are either dismissed on grounds of jurisdiction or admissibility of claims. And even if they go past that stage, the damages that are often awarded to investors don't fully represent the damages that were claimed. But James, you may have used them.
No, I just wanted to add that the Philip Morris cases against both Australia and Uruguay were the other poster childs, other than Vattenfall, for why we needed ISDS reform. And it was really largely based on the fact that Philip Morris had filed claims. But of course, Philip Morris lost on those claims. So that's, I think, an important point to
Yeah,
learn.
and I also wanted to say that one should also look at the UNTAD database, because that's when you can see sort of how many cases have been decided in favor of states, in favor of investors. Recently, I was speaking very specifically about ASEAN. ASEAN, Singapore is part of ASEAN. Every single ASEAN state has been sued as a respondent other than Singapore. But the percentage of ASEAN states that have prevailed is about 70 to 80%. So I think we need to look at the whole database and not just certain publicized case.
I appreciate your answer and concern. But you see there's a global trend because of which the countries like India have to modify their model BITs from which they have removed the
Let's
MFN.
give the
Sorry.
floor to someone else. Thank you. Anyone else? Yes.
Good evening. My name is Disha. My question pertains to what happens with the rise of the principle of party autonomy, with the rise of hostile states. How does the core principle of arbitration get affected, and what can be done in the future to prevent this? With the rise of hostile
Would you
nations.
like to clarify further?
Yes, sir.
Yes.
So, for example, with the rise in hostile nations, right? With the Russia-Ukraine war, for example, right? When parties are unable to choose to enforce the awards or even go ahead with arbitrations in the agreed upon terms, how can that be prevented in the future?
So I think one of the most important things that we have to really be protective of in arbitration is accessibility, to make sure that arbitration is accessible. So if the parties have agreed to a dispute resolution process where they are able to have that dispute resolution process manifest. I think that I always hearken back when it comes to sanctions and armed conflicts, the tripartite note from LCIA, ICC, and SCC, in that the existence of sanctions per se don't prevent the administration of an arbitration. And in terms of eventual enforceability, I think that's one of the choices that you would have in the asset tracing phase of deciding whether or not you want to go to arbitration. And that perhaps one of the good things about dispute resolution in 2025, we're starting to look at combinations of dispute resolution procedures. So maybe this is better to settle out, to mediate out some kind of combination process as well.
Anyone else? Okay. I don't see any further hands. So, yeah. Yes.
Thank you, sir. Good evening. My name is Surendra Kara. My question is to Manish ji and Mr. James, that regarding what you said about International Court of Justice and the American Court of International Justice, in fact, all those things, what ICJ had taken into consideration was GST1, AR5, AR6, and all the IPCC recommendations. Those are already mentioned in our epic. Kautilya Arthashastra says everything of the same thing, that it is the estate duty. And that was the decision on 23rd of July. On 27th of July, Sri Lankan Supreme Court has given a decision of the same thing and given imposed a lot of penalties on the state, which the ship which had to carrying a lot of poisonous pollution and all those things, they spoiled the entire coastal area there. Now the same thing is being implemented. How is it going to happen? What is the effect on that? What the UN headquarters are going to do after this decision? Because that was a recommendation from the UN headquarters to the International Court of Justice. There are some young students in Kiribati and other island countries.
I think if I understand your question correctly, it's more in terms of what the next steps are, given that you now have the advisory opinion, how that might manifest itself.
Exactly. But the only thing is that how is the UN going to ratify that decision? It is not that it has been pronounced, so it will be a guiding force for all the states. But it has to be ratified, and then it is implemented by the members of the United Nations.
So I think the way I look at it, and I'll be interested in the views of others, is that advisory opinions obviously are not binding on states, but I don't think they necessarily would require kind of a ratification to have an effect, because what you have is the highest kind of court interpreting international law, confirming that you as states, the states, have binding obligations and obligations that already exist. So the ICJ is not creating new obligations, it's confirming the existence of obligations. That's the first point. The second is, often in the context of climate change debate, you have a view that some of these obligations are hortatory. They are kind of more obligations in terms of, conduct. I think that was an expression that was used. But I think the ICJ has come out and said, look, these are not simply voluntary or aspirational obligations. These are binding, substantive, and enforceable obligations of the states, such that if states do not comply with these obligations under both international treaties to which they are parties or under customary international law, which obviously binds all states without any further ratification, then the states would be committing an internationally wrongful act. And there would be consequences under international law, including an obligation to make full reparation in the form of compensation. So I think that this is going to have a huge impact. And again, you can see, particularly in the kind of cases we deal with, both states and investors relying on the opinions to try and give new substantive meaning to the obligations that already exist. So I don't see this as necessarily as just kind of, introducing something that needs to be now further ratified. But that's my view.
No, in fact, on 23rd of July.
You just wait for the next session. There will be more elaboration on that. There's going to be more debate. One of the speakers is going to speak on that. Anyone else? Yes.
Good afternoon. My name is Nishtha Aggarwal. My question is to the panel entirely. ISDS has been facing or suffering from some legitimacy issues on and off. So does the panel believe that a multilateral investment court would be beneficial generally for the system, or should there be an appellate mechanism regarding this? I know there's been a debate on and off regarding this issue, but I just wanted the views of this panel particularly.
I think, and I'm not supportive of a multilateral investment court, because to me, and I think we spoke about this earlier, and James said something, and I was like, I entirely agree with you. You do not want another ICJ. The idea and the reason why ISDS work is because it's depoliticized, and that's very important. So while I must say, EU has been very successful in its recent treaty negotiations, so with Singapore, with Vietnam, it's managed to put in place a permanent tribunal and appellate mechanism. That is the dispute resolution provision that they have successfully negotiated with us. And of course, with that, we have to go through that mechanism. But should the entire system change? Not in my view.
I think we have run short of time. We have overstepped the time. So I would thank the panelists for this very enriching discussion, which I hope also got you interested and jolted you out of your afternoon, drowsiness or whatever. So it's been very enlightening for me, and also a privilege to be amongst all of you. Thank you, James. Thank you, Manish. Thank you, Ko, and Kevin. So I would invite.
I would like to thank our distinguished speakers. May I invite Honorable Mr. Justice Sachin Datta to kindly felicitate the chair and the speakers with a Prabhavali. The Prabhavali is an intricate brass work which is a representation of traditional Indian arches on the base of some traditional Indian textiles. Thank you very much. May I request the panel to stay for a picture with Justice Datta? Maybe you can step ahead.
Thank you.
Thank you very much. Thank you very much. We will be starting the next session shortly, so I would request all delegates to come back to this auditorium and resume their seats. Thank you.
Yeah.